Good afternoon, everyone. My name is Damola. Thank you for joining us once again on another section of our Facebook Live. This afternoon, we'll be talking on alternative dispute resolution. We'll be looking at various ways in which we can resolve disputes. Can be business disputes, can be family disputes. But generally, we'll be talking on how we can explore ways in resolving disputes that we may have to that might come across our paths when we are dealing with partners or when we have to go into a contract agreement. So generally we'll be discussing on ways of resolving disputes aside from the court settings. And one thing that comes to the mind of everyone out there is once a person introduces himself or herself as a lawyer, what comes to their mind is court. And when people have to go into engagement, when they are engaged with someone else and there is a breach of contract or a breach of the terms of engagement, the first thing that comes to people's mind is to go to the court. While it is not in doubt that the court system is an arrangement or is a setup or a structure where people can go to resolve that may arise in their interaction with other parties. In doubt, the court is where people go to resolve disputes. Disputes are meant to be resolved in the court, and that is what is being done in the court. That's what the court is for. But then this afternoon, we'll be looking at other ways in which you can resolve legal disputes, even though you have the court to go to where you'll be where you have to engage the services of a lawyer and you have to adjudicate or present your matter before a court or a judge. And this is that this is one very good way which you can enforce or resolve disputes that arise in your relationship. Another thing people believe is that once you get to the court, that is the only place where they can have their matters resolved. So this is something that will be afternoon. So by way of definition, let me just start by saying that dispute resolution revolves around the process of resolving disputes. And in Nigeria and the world at large, when we talk about dispute resolution, particularly legal matters, there are various structures put in place where people can resolve their disputes. And some of these structures include a visit to the courtroom. We also have other ways of resolving disputes, which we'll be looking at this afternoon. Aside from going to the court to have your matters resolved or to have disputes resolved, we also have other means where you can resolve your dispute, and these other ways includes negotiation, we have mediation, we have arbitration. And when we talk about negotiation, negotiation involves the parties involved generally. So this is to say where I enter into an agreement with someone and there's a breach of the terms of the agreement, I can approach the person who is in breach to discuss on amicable ways of resolving the dispute. So this is to say I'm calling the person to order to remedy the wrong that has been corrected, or where a person has failed to perform his obligations in a contract agreement. I can call the person to resolve on how to go about it. And negotiation can include you saying that since you have refused to carry out your obligation, you can suggest ways where parties can part without having to cause any offense, or where you can just end the relationship such that there won't be any loggerheads, or where someone would have to create a bad impression of you. So negotiation basically revolves around the two parties. Then when we talk about mediation, is now bringing in party to intervene and also advise parties on best practices to adopt in resolving the dispute. And with the few points I've discussed there, one thing we can note is that these practices has long been in operation even before the advent of the court system. So we've seen cases where someone would offend you and what you do is just to approach the person so that you can resolve amicably. Then for mediation, this is calling a third party, someone who you feel can discuss, someone who you feel parties respect, and someone who can advise parties on how to go about the dispute. So these are alternative ways of resolving dispute. But then there are some other ways, there are some other provisions, other dispute resolution methods, which if you want to adopt negotiation, if you want to bring in, if you think it's something you can resolve, or you want to bring in a third party, you feel that this is something that the other party might not really appreciate. So if the person you are dealing with is someone you know that if you approach the person personally, the person will not really take you serious, or might not actually want to bind himself by his undertaking, because you can negotiate with someone and the person will make an agreement to perform his task or remedy the wrong, or even where third party is involved like a mediator, the person can still not abide by the things that have been agreed on. So if you feel the person you are dealing with is someone that will not appreciate negotiation method, or you feel is someone that will not appreciate a mediator coming in to mediate between parties, there's also another one which is called arbitration. And this arbitration is also like mediation, but the difference is that the proceedings or the decision of an arbitrator is binding on parties. And arbitration generally or is something that is kind of court related, because in we have different court systems or the rules of court or various courts in Nigeria now. We now have provisions in the rules of court. The rules of court are provisions of governs how disputes are to be resolved. So every court in Nigeria has its rules of court, and the rules of a particular court differs from another court. So the rules that bind a Lagos State High Court does not bind an High Court sitting in the Federal Capital Territory. So these rules of courts now provides for alternative ways of resolving disputes, such that not all matters will be taken to court. And you will also agree with me, and there's this adage or proverb that says that you don't go to court to become friends with the person you took to court after the whole matter is over. Even from the moment you file the court process, and from the moment you serve the other party the court processes, when the person receives the court processes, there is this enmity that is being created. So these are some of the things that AGR, that is alternative dispute resolution, these are some of the things that it takes. So even while you are resolving your matter, why someone has done something wrong to you, or when someone has breached a contract agreement, you can resolve the matter such that even after the resolution of the dispute, your business can still maintain this relationship with that person if you need to maintain relationship. But then the part or the fact that there's this hatred or anger that you took the person to court, that is taken off from the transaction. So I was talking about the fact that some of our court rules now provide for alternative dispute resolution, to the extent that parties are advised to first resolve matters amicably even before filing an action in court. For example, in Lagos State, if you want to file an action, you want to file an action against the person if let's say someone has wronged you or breached a term of an agreement. Before taking that person to the court, the Lagos State High Court rules provides that you need to first sit down to discuss with the person on how best you can resolve the dispute. And even after you've explored that, if you are still unable to resolve the dispute, the rules again gives it confers on all lawyers. So if you want to engage a lawyer, the rules also gives the lawyer or mandates the lawyer to also try to resolve the matter amicably or try to call parties together. So this is to say that even when you approach a lawyer to file an action in court against someone who has wronged you, the lawyer still has a duty to advise you to explore possible ways of resolving a dispute without having to file the action. And this is to say that all lawyers also have a duty to advise their clients on other ways of resolving dispute without having to go to court. So it is after you've explored all means of amicable resolution of dispute or all ways of resolving a dispute, the court intervention. It is when this this procedure fails, that is when you cannot file an action. So this is to say that alternative dispute resolution or out of court dispute resolution is a very good practice of resolving disputes which everyone should embrace in a legal system these days. And another thing that should be noted is that when you go to court, you don't go to court and you file an action today and you wrap up everything within 24 hours or within a week. The court is a court of process, is a court that processes are being complied, procedures are being laid down and they have to be complied with. So if the procedures of the court says that this thing within which you can do this thing, you have to comply with that time. For example, when you initiate an action in court, for some rules of court, you have 3 months, some say 6 months to serve. So if you file an action this in a month and you still have 6 months before even the matter can be assigned or before you can commence trial in the matter, that is to say that for 6 months where you could have actually explore alternative dispute resolution, alternative resolving your dispute, you keep waiting for 6 months for the court to start trial, and the other party can even come and say they didn't get the process or something like that. People can bring the matter can keep lingering in court and you can be on it for years, and the reason why you are in court you've not been able to achieve it. So this is to say that if your matter is something that can be resolved amicably instead of going all the way to court, it is best advised that you explore this amicable ways of resolving a dispute. For example, let me give an instance. There is a claimant we have to represent, and at the point of at the point we were briefed, we called the other party, the party who is in breach of the agreement. We called the other party and also tried to mediate between parties, but resolution. So this is to say that even while you file an action in court, while the matter is already going on in court, judges have the power to advise parties that are before it to explore dispute resolution. So for the case I was trying the story I was saying, I was narrating, at the end of the day, the court still directed that the matter be resolved amicably. So after like 2-3 years of going to court, parties still had to resolve the matter even without the court giving judgment. So we still had to explore amicable resolution, and that was what the court made its judgment. So this is to say that even when you resolve your matters amicably, especially when you go through arbitration, you can enforce the agreement or the undertakings that parties have made. You can go to court to enforce it. For example, in Lagos State, we have the Lagos Multi-Door Courthouse, which was established in 2002. It is a court-connected ADR mechanism. So this is to say that if you're in Lagos State, you can visit the Lagos Multi-Door Courthouse, and this is a mediation center that is connected to the court. So this is to say that any decision made at the Lagos Multi-Door Courthouse, you can apply to an high court in Lagos State to enforce it. And another thing is that even where a mediation or an arbitration proceeding is carried on in a state, you can enforce it in another state. So another reason why this will take me to the fact or excuses people give for exploring mediation, because people feel that once you are able to resolve your matter in an arbitral panel, you cannot or you won't be able to enforce it in another state. That is not the position. If an arbitration proceedings is being commenced in Lagos State, you can enforce it anywhere, so long as it is a validly binding arbitration. If the procedures are properly carried out, you can enforce the judgment that is given at the arbitration panel. You can enforce it in any court in Lagos, in any court in Nigeria, and even outside Nigeria, so long as the arbitration panel is well conducted and is well structured. So there are proceedings that there are procedures for arbitration. So if you are looking at arbitration, there are procedures for the appointment of the arbitrators, the sitting of the arbitrators, how decisions are to be made. Once all these are complied with, you should rest assured that where you seek to apply, to enforce the judgment or the decision that is given by the arbitral panel, you can validly enforce it in court, and that will be binding on the parties. And another advantage of arbitration or alternative ways of resolving your dispute is that it keeps your business secret, because once you file an action in court, it becomes a public record or a public proceedings. Proceedings of the court are done in the open court. You don't go to court to have your proceedings between yourself and the judge or your lawyers. Proceedings are conducted in the open courts, where even people that are not interested in your matters or people that don't have anything to do with your matters, they have the liberty, they are free and they will be allowed to witness your proceedings. So this is to say that where your matters are being carried out in a court system, there is little privacy you can have to such matters. So this is to say that the matters become a public record and something that is easily accessible to the public. And so this, and another advantage of arbitration is that it is faster and it can be cheaper at times, especially where you are exploring negotiation or mediation. If you are exploring arbitration, you still have to pay the arbitrators, that is the panel of people, the third parties who are coming to intervene. But then arbitration is cheaper and it is affordable. Then you are able to keep your business secrets. Nobody knows what is being done behind closed doors, unlike a court sitting where it is done in the open court. But for arbitration or other ways of resolving dispute, it is usually between the parties that are in dispute or the parties that need to resolve their matters and their lawyers, and also a third party, which is the arbitrator or arbitrators, where the arbitrator is more than one. So this is to say that your business secret is not prone to the open like that, unlike where you have to file your matter in court and everything goes through different offices and different desks, such that people can easily know what is going on in your company, and it may not be a good one, particularly if your company is the defaulting party and people keep seeing the wrongs that is being committed and the like. So at times, for you to protect your business interest, particularly for business owners, it is advised that you explore amicable ways or alternative ways of resolving your dispute. So by way of conclusion, I would want to say that the agreement between parties, when you are drafting your contract agreement, should be noted that you are bound by your contract agreement or the clauses that you've agreed to bind your contractual relationship. So at the point of negotiating your contract, it should, one of the clauses or one major clause that you should take note of or that you should agree on in your contract agreement is a dispute resolution clause. So the dispute resolution clause should provide for how you want disputes to be resolved. So if you desire that any dispute that should arise in the contractual relationship, or where someone is in breach of a terms of the agreement, you can provide in your contract agreement that the dispute should be resolved amicably, or you can also provide for ways. So you can give procedures such that you can say you want to start with negotiation or mediation or arbitration even before pursuing a matter in court. So your contract agreement can contain clause to the effect that until parties have first explore alternative dispute resolution, and where that is not done, the other party cannot go to court. So this is to say that you can have in your contract agreement to say that before anyone should go to court, the person should first explore alternative dispute resolution. This resolution can include arbitration, mediation, or negotiation. And you can also state that only arbitration should be explored. So this is to say that you can have in your contract agreement that all disputes is to be resolved by arbitration. And in this clause on dispute resolution, you can provide for a way of appointing arbitrator who appoints the arbitrators that should preside over the matter. Then you can also talk on the place of resolution of dispute. So this is to say that, for example, where one of the contracting parties is in Lagos State and the other is in, let's say, Abuja, it is understood that these parties are in different locations, so you can both mutually agree on where you want dispute to be resolved, such that it will be a place that is convenient for both parties, such that it won't, at the point of resolving the dispute, the cost of transportation or the stress of transportation won't be something that would discourage the person from enforcing a wrong. So you can, apart from agreeing to resolve your matters amicably, as apart from agreeing to resolve your matter, to refer your matters to an arbitrator, you should also discuss on the place of arbitration. Then another thing I would also want to add is that aside from the courts also encouraging people to resolve disputes, there are also government institutions or government organizations that now encourage dispute resolution. For example, the CBN now has some provisions of the laws, from some rules and guidelines that encourages parties to first explore alternative dispute resolution. For example, in Lagos State, we have the mortgage bank. There's a dispute resolution panel that is being set up to manage mortgage transaction. Also, for chartered institutes of bankers, there's also an arbitration panel, to a structure that is put in place. So this is to say that alternative dispute resolution is one mechanism or process of resolving disputes that should be encouraged, as business owners or people who might have to go to court for matters which can be resolved out of court. Though there are some matters that cannot be resolved out of court. For example, criminal matters, you need to go to court to, the court only has jurisdiction to resolve criminal matters. But when it comes to civil wrongs, there are some civil wrongs that you can easily resolve without having to go to court. So with these few sections that we've had this afternoon, I believe we'll be able to resolve our matters amicably, even while we are still retaining business relationship in all our contractual dealings. And we should not forget to include arbitration clauses or dispute resolution clauses when drafting contract agreement, and also to prioritize amicable ways of resolving disputes, such that parties can easily resolve disputes without having to stay long on matters that can be resolved within few hours or few moments or minutes. I hope we've been able to understand that the court is not the only way where, or the only way or option where you can resolve your matters or dispute that will arise or that have arisen in your contractual relationship. We hope to have you again next week on another section of our Facebook Live. Thank you for watching, and continue to keep safe and stay safe.